Thank you for announcing me. Thanks for the applause. I hope I can live up to the expectations. Well, brave souls at any event that you're here so early in the morning. Panos is speaking in the parallel session, so I guess many of you went there. Good. First of all, thanks to Panos, although he's not here, but Nina, you represent Panos, I assume, so also thank you, Nina, for inviting me here, because I understood you also tipped Panos to invite me somehow, and it's nice to be in the same panel. And Nina worked with us in Utrecht, so it's also nice to see Nina again, and I think Nina's presentation will also relate to what I'm going to say. Now, in fact, it's a shame that this is only my first time in Groningen. I have to admit that. I have to live up to that. I know it's unforgivable because I live just south of Groningen, relatively speaking, in Utrecht. But I'm here now, and I hope to come back later. And I would also like to congratulate the whole team on pulling off such a fascinating event, but also project. I mean, it's a theoretical doctrinal project, and I know how difficult it is to get funding, like from ERC or from other funding agencies. So that is quite an achievement already, I would say. Now, as the title of the panel already indicates, we will look at domestic courts and interpretation. So I will look at interpretation of customary international law by domestic courts. As Ingo indicated, more generally, although I will only look at a relatively limited number of domestic court decisions, because I didn't find that many. Now I understood from Nina that you have established country teams and that you will find possibly many more of these cases. I was not able to establish those country teams, so I was basically stuck with the existing databases. But interestingly, I learned something from that, and I also hope you will learn something from that. So I espouse a more empirical approach, let that be clear, rather than a theoretical approach, which will then be taken by Nina. Now, domestic courts, as you may know, are important agents of international legal development, and as André Nolkemper has said and written in a well-known book, they contribute to the international rule of law, or the rule of international law, so we cannot turn a blind eye to the practices of domestic courts. And I've dealt a lot with domestic court practices relevant to customary international law. I would not consider myself to be a CIL specialist, but I've worked a lot, as some of you may know, on jurisdiction and immunities. And our presentation today will be mainly about immunities, or will relate to immunities. I'm not interested in the substance of immunities, but rather the methodological interpretive moves that are taken by domestic courts. Now, all this ultimately led me also to publish a more encompassing paper on customary international identification by domestic courts in the Netherlands International Law Review 2018, which is available open access if you're interested. So I'm building a bit on that, but I wrote a different paper focused on interpretation. And I think that paper also explains why Panos invited me to this panel. I will not repeat the conclusions of that paper, but very briefly, the outcome of the research was that domestic courts do not normally identify customary international law norms on the basis, well, of the classic idea of, well, you look at state practice and you look at opinio juris. Rather, they tend to outsource this to other agencies and instruments, that they would look at international judicial institutions, to treaties, to non-binding documents, and even to the doctrine. And sometimes they just posit the existence of a CIL norm without really inquiring whether it exists on the basis of state practice. And all this is in fact in keeping with conclusions reached earlier by Stefan Talmon into relevant ICJ practices published in the EGIL 2015. But the important takeaway here is that domestic courts do not always, and not normally even, find customary international law themselves. And then they may just give effect to, they may apply pre-existing customary norms that have already been identified, have already been crystallized before. Now, if that is true, there is in principle room for interpreting customary international law, and I refer here to Panos' earlier work. Interpretation focuses on how the rule is to be understood and applied after the rule has come into existence. So assume that the rule has come into existence, has crystallized, then the next step might be interpretation. I think that is the approach also of the TRICI project, and I think, Nina, you might say a bit more about that if you want. I'm not here to present the assumptions or premises or conclusions of the project, but I've read Panos' work and I tried to build also on Panos' work. I was initially, I have to say, a bit skeptical whether customary law could be interpreted in the first place, and I've thought about that. But doing the actual empirical research, I came to the conclusion that domestic courts seem to be doing that. I tried to refrain from particular normative statements in that respect, but what I will do with you is to describe what courts are actually doing. So in my earlier research, I just focused on ascertainment. I'm a bit of a newcomer to interpretation, I have to admit, but I decided to look at the relevant court decisions again, the ones that I looked at for ascertainment and even more, and donning a specific lens, an interpretive lens, so I became an interpreter. And from a technical perspective, as I said, I looked at the ILDC cases using a number of search terms, and ILDC is very accessible, so it works really well. ILR from Cambridge works a bit less well, so I didn't really look at that also for lack of time. Now, I will no longer keep you waiting. The research did yield some results. However, there were a number of false positives. I thought, hey, we were pregnant here, but we were actually not pregnant. So we're talking here about results which did not relate to customary international law interpretation in the strict sense of the word, or even properly not interpretation at all. So we have these courts saying that they interpret customary international law, while in fact they ascertain or identify customary international law. Found a number of decisions, I will not list them all, just one here, a quote from the US Court of Appeals of the 11th Circuit. So the court describes the determination of what offences violate customary international law is no simple task. We know that also from yesterday. This is a complicated field. There are myriad decisions. The evidence is widely dispersed. And then in the end, they say all of these characteristics give customary law an indeterminate character that is subject to creative interpretation. So this is interesting. Is this really interpretation? No, it's not interpretation of customary international law. What the court is describing here is what is sometimes called evidentiary interpretation. It's parsing state practice, parsing the evidence. And this is really law ascertainment. So you analyze state practice with a view to ascertaining customary norms, and this is not interpretation of existing stabilized customary norms. A second false positive, which you find a lot actually when you do the research, very large category, is called really engaging in interpretation, no doubt about that, but not of customary international law, but of domestic law, statutory law typically, in light of customary international law. We call this völkerrechtskonforme Auslegung, consistent interpretation, quite well known to you. So this is in light of customary law. You don't interpret customary law as such. Another false positive. I became a bit tired and I thought, will I find true positives? Because in the beginning I only found those false positives. But I did find true positives, decisions in which courts, domestic courts, genuinely seem to interpret customary international law norms, in which they try to understand the meaning of a given customary norm in a given case. Does it apply to ducks? Does it apply to rabbits? Or does it apply to both of them? And that we have such cases is really a significant finding because it demonstrates indeed that domestic courts at least assume that they can interpret customary law norms. I have a decision of a Belgian Court of Cassation 2014, animal capital, state immunity from execution, where the court said, of course in French, but translated into English, domestic courts identify and interpret rules of customary international law. So apparently the Court of Cassation, High Supreme Court in Belgium, believes that there is something like law identification and law interpretation in relation to customary law. But it remains that domestic courts have not given much thought to the doctrinal underpinnings nor to the normative consequences of customary law interpretation. Let's be honest about that. Now, most relevant domestic court decisions relate to immunities. And this is not surprising because immunities are normally invoked before domestic courts. And the law of immunities is one of the few fields of international law that is still largely governed by customary international. There are not many treaties in this field. So this is very much a story on immunities, but as I said, I'm only interested in interpretive moves. The research which I carried out yielded 3 analytical categories which were constructed on the basis of grounded theory research. The first one is autonomous customary law interpretation. The second one is deference to interpretation by other agencies, in this case typically international courts like the ICJ. And the third one is interpreting customary law norms by resorting to codification, actually, norms being laid down in treaties or other authoritative written documents. Autonomous still interpretation, so this is basically courts doing it on their own, their interpretive work, they don't rely on other interpretations by other agencies. So most of these decisions actually pertain to immunity ratione materiae of state officials from foreign criminal jurisdiction. Again, this has not been codified, at least not until recently with the work of the ILC, and international courts have given little to no guidance. So an ideal case perhaps for, on the one hand, obviously identification, but perhaps also interpretation. If you look at this decision, the Swiss Federal Criminal Court 2012 on immunity ratione materiae in relation to jus cogens violations, read the last sentence. So the court refers to the commitment to repressing jus cogens violations on behalf of the Swiss legislature, the Swiss government, was an additional reason for denying A's immunity ratione materiae, as it would be contradictory to express such a commitment while giving a broad interpretation to this immunity which exists under customary law. So what is happening here is again a matter of interpretation. Is in itself amenable to customary law formation, and then you would look at sufficient state practice to buttress the crystallization of a customary law exception to the immunity ratione materiae of state officials. So the exception is also subject to customary law formation. Yes, this is one reading. The alternative reading, one espoused here by the Swiss court, I would say, is that according to the court, the customary law immunity norm has already been established. I know, Ingo, you take issue with that, I think from a more theoretical perspective. But what we see here, in my view, is that the court says, yes, there is such an established norm, but meaning is given to that norm in a specific umfeld or specific milieu of international crimes. And practice may be relevant to understand this meaning, but I would say then as subsequent practice in the sense of, like paraphrasing, I would say Article 31.3b of the VCLT, subsequent practice in the application of the customary norm, which establishes the agreement of states regarding not its identification, but its interpretation. Secondly, deference to still interpretation by international courts. This is indirect interpretation, I would say. It's not direct interpretation, but still such decisions are relevant in that they confirm the methodological validity of interpreting customary international law. I've just discussed this with Luigi. He will discuss Italian court practice, but he's not going to discuss these two cases, so I will briefly mention them. These cases relate to decisions on the immunity of states by the International Court of Justice in the famous jurisdictional immunities of the state case, Germany versus Italy 2012. So we have two cases here, one Simoncioni by the Italian Constitutional Court, the court referring to the interpretation by the International Court of Justice of the customary rule on state immunity for active imperium, black and white. The court says the court, ICJ, is interpreting customary law here. In Alessi, we find something similar, an interpretation here on jus cogens by the International Court of Justice. Now, this is interesting because the ICJ did not explicitly use the term interpretation. So this is a secondary level interpretation by domestic courts. But on closer inspection, in fact, what the ICJ did, perhaps it may have interpreted the territorial tort exception in the case and the scope of state immunity from execution, which are customary international law norms, which are, however, laid down either in a treaty or in another instrument that is authoritative, like the UN Convention has not entered into force, as you may know. And this then brings us to the last category, that's interpreting customary law norms laid down in authoritative written documents, as I explained already regarding the ICJ. What are domestic courts doing here then? So here the idea is that supposedly the customary international law norm has already crystallized black on white, because the idea is really that codification gives customary law a more stable existence. And I think this is also the aim of codification in many instances. And this then shifts the analytical focus from ascertainment identification to interpretation. An example here is the US Court of Appeals in the Sea Shepherd case, interesting case regarding environmental activism, whether it qualifies as piracy. The court referring to other practice by Belgian courts, and this interpretation of customary law by Belgian courts is entitled to considerable weight. What is happening here is in fact an interpretation of the customary international law variant of Article 101 of the UN Convention on the Law of the Sea, to which the United States was not a party. So they're interpreting 101 of UNCLOS, but they cannot technically interpret UNCLOS, they have to interpret the customary law variant. And you see that quite often, actually. There's also Israeli court practice in this respect. So this is quite interesting. Then, Ingo, I think my time is almost up. So I will move to the concluding observations. We've talked a lot about fictions yesterday, and domestic courts also here use the fiction, I would say, that they find, they ascertain, they identify customary international law, whereas in reality they have rather limited agency in this respect. But they do apply, they do interpret, they do develop customary international law, although, truth be told, they don't often use the term interpretation, although that was a search term that I used. In any event, the practices which I discussed, which I looked at, they bear out that domestic courts may consider some customary international law norms to be relatively stable, like norms on immunity, and thus amenable to further refinement through interpretation. I think this is in keeping then with the premises, the assumptions also of the TRICI project. So that came also as a bit of a surprise to me, but I thought these were highly relevant findings. And when interpreting customary international law from a more technical interpretive perspective, it seems to me that the courts apply two main techniques. The first one is systemic interpretation, interpretation in light actually of other rules of international law, and in this case that would be very much rules of treaty law and treaty norms, and they would also look at interpretation on the basis of subsequent state practice, as I mentioned before, and this is then in keeping with Article 31 VCLT. So it might be the case that we have a customary law variant of Article 31 VCLT developing, and I think this is also what Paulus wrote earlier. He believes that the customary rules of interpretation are also customary in themselves. Now, in future cases, and this is my final sentence, in future cases perhaps domestic courts can be a bit more open, a bit more transparent about what they're actually doing. Are they actually interpreting? Are they identifying? And look closely at the terminology, because I've seen that yesterday as well, that sometimes there was like loose use of the term interpretation, whereas in fact identification was meant. And I think this is key to clearly make that distinction between both terms. So we're talking about a relatively stable norm, and then we move to interpretation. So there's still a bit of doctrinal work to be done here, but the takeaway of this presentation is that domestic courts do believe that in some instances they engage in interpretation of customary norms. Thank you for your attention.